first public meeting of the Terminally Ill Adults End-of-Life Bill Committee. Before we begin, I would like to say just a few words to explain why we are here and what we're expected to do, and indeed what not to do. The bill has had its second reading. It has been committed to a committee of the whole House where it will receive line-by-line scrutiny. Many amendments have already been tabled, and more are likely to be put down in coming weeks. I understand that the date set for the first day in committee is Friday the 14th of November, and we have been given a date for our report, which is the 7th of November. What then is the purpose of this committee? It is a select committee separate from the proceedings on the bill in the House. Its purpose, and indeed its only purpose, is to obtain information before those proceedings start on Friday, 14th November. This is so that the House will have the benefit of the expertise and insight of the professional bodies and others with professional and practical experience, and others who will bear the responsibility of carrying out the functions that are provided for in the bill. What we will be doing, in short, is finding out what in those provisions will work, what will not work, and indeed what needs to be done about them. The House needs this information before it undertakes its detailed scrutiny. I must make it clear that it will not be for this committee to draw any conclusions or to make any recommendations from the evidence that we will receive. There is no time for us to do that, and it's not our function. The function that we will be performing in these next 3 weeks is very important, but it is limited to the gathering of information by taking evidence, by questioning the witnesses who are appearing before us. Their evidence will be broadcast live and recorded, and it will be published in full. The transcripts will be added to our website week by week. Finally, we aim to have a full set of evidence published on Tuesday, the 11th of November. That means that the House will have that evidence before it begins its scrutiny. One final point that I would like to make before we begin is about the substance of our proceedings. The committee will be dealing with highly sensitive matters, of which many people taking part, or watching, or listening, may have direct personal experience. I'm sure that we will all wish to approach these very important matters with all due care and respect. Well, welcome to the first session of our inquiry into the Terminal Ill Adults End-of-Life Bill. We are joined in this session by Lord Falconer of Thoroton and by Kim Leadbeater, MP. You are both extremely welcome, and we look forward to your evidence. We will be grateful in a moment if you would introduce us very briefly, and then we will proceed to questions. I remind you that this meeting is being broadcast, and a verbatim transcript will be available, which will be then sent to you to check for accuracy. And we refer to our list of members' interests as published on the committee's website. So I think, Lord Falconer, for you first, if you will be kind enough just to say a few words, and then I'll pass to Kim Leadbeater.
Thank you very much indeed. In terms of declaration, I have the support of an assistant funded by Bernard Lewis for work on this bill, and Dignity in Dying funded the printing of literature on the bill sent to peers prior to the second reading. Thank you for inviting us both to give evidence today. I'm the sponsor of the bill in the Lords, and Kim is the sponsor of the bill in the Commons. Throughout, we've worked as a team and take joint responsibility for the bill. Our positions should be regarded as joint positions. We welcome the calling of evidence before this committee. The House as a whole values the work of its committees because they are trusted in relation to evidence to act in a balanced, impartial way. Because this parliamentary session will last until the spring, this House has time to inform itself with evidence before your committee and then to scrutinise the bill in the Lords through the normal legislative process on the basis that this committee completes its work before the 7th of November. The government once this bill got a second reading in the Commons, has provided the sponsors both with significant assistance in the drafting of the bill and substantial technical advice on how to make the bill workable. They have done so without abandoning the government's neutrality. I have long experience of shepherding government bills through Parliament. The quality of the official help we have received on this bill has been extensive and excellent. On the basis of the support we have received from officials, we have no doubt the bill is workable. Experience from other jurisdictions confirms that expectation. This bill builds on the extensive work done on this subject in both houses over years. We have the benefit of learning from over 30 other jurisdictions who've made the change. Indeed, around 300 million people around the world have access to a legally assisted death. Bills to change the law have been introduced in Scotland and the Isle of Man. Reform is coming. The current law in this jurisdiction is simply not fit for purpose. Just last week, Louise Shackleton found that having accompanied her husband to Dignitas, she faced 10 months of criminal investigation. Do people deserve this on top of their grief and loss? Finally, constitutionally at the heart of our parliamentary democracy is the primacy of the Commons, because they are elected and we are not. Ultimately, it is for the Commons to make the decisions on assisted dying. It's not for us, secular or spiritual, to make the key political decisions on this issue. We should not assert that we know better. This bill affects the legal changes which are necessary and appropriate to allow those who want an assisted death in their terminal illness to have choice at the end of their life. It's subject to safeguards which are manifestly lacking in the current law and are probably the most stringent safeguards among assisted dying laws in the world. Thank you very much indeed.
Very much. Would you like to add anything, Kim Ledbetter?
I will. Thank you very much, Chair, and thank you to the committee for giving us the opportunity to come and speak to you and for making a few opening remarks. As Charlie says, the benefit of your Lordship's experience and expertise is very welcome in scrutinising this bill. Public support for changing the law to give terminally ill adults choice at the end of life has been very strong for many years, and it remains so. But we owe it to them to get this legislation right. We've all got our own experiences of death and dying, but I think it's impossible to imagine what it must feel like to receive a terminal diagnosis and be told that you've only got a few months left to live. The uncertainty, the fear, the lack of control. For those people and their families, this debate is not an abstract concept. It's not a political game or a series of clauses and amendments. It's a very emotional and traumatic reality. People like Nat, Shafak, Angela, Anil, Katie and Mick who are here on the public benches today. People who know from painful personal experience that the law as it stands is unjust, unenforceable and frequently very cruel. I fully respect the views of those who will always be implacably opposed to assisted dying, and I know that includes some people on the committee and others who will give evidence to it. But the elected chamber, reflecting the views of the public, have decided that the law should be changed. The bill before you has benefited from extensive evidence received in the Commons, 50 witnesses giving oral evidence, 444 pieces of written evidence and 100 hours of debate. And as Lord Faulkner said, it's also benefited greatly from the expert drafting, advice and guidance from an outstanding team of civil servants and parliamentary counsel. As a result, it is an excellent piece of legislation. But if through constructive scrutiny and working together it can be further strengthened, then I for one will be more than happy. From my experience as sponsor of the bill in the Commons, if we work together collaboratively and in good faith, we can do the job we are here to do and we can show Parliament at its best. The issues that you're addressing are not new though. We're not breaking new ground. This happens in countries around the world, and I hope the committee will also read the Health and Social Care Select Committee report from 2024, and they did a 14-month investigation into this issue, so there's huge amounts of evidence there. Drawing on the experience of other jurisdictions where very tightly defined legislation like this has been in place for quite some time. So international experience shows us that we can offer dignity, compassion and choice to terminally ill people. And I want to thank you all for the input and the important role that you're going to play in making that happen.
Thank you very much indeed. Baroness Hayter.
Thank you, Lord Chair. As the Chairman said, we're looking to make this workable and look at problems. So I'm interested in two things. Well, one thing, of the problems, and you've heard, the issues of the problems with the bill, what have you learned, both from families, either those ill or their families around them, and indeed from international experience, to address the sort of problems that have been raised about the bill?
You go to that.
Yeah, look, it's been a long journey, and I've spoken to lots and lots of people, lots and lots of organisations, but what I've tried to do throughout that process has always look at the status quo as it is now. And that's the problem that we're trying to fix, and that's why the law needs to change. And the voices that are really important to be heard in that are the people who have suffered as a result of the inadequacies of the current situation. So hearing from people with lived experience who have felt the injustice of having a situation where people who are terminally ill feel they have no choice other than to either take their own life because they feel so desperate, or they have to make the very difficult decision to go to another country, to Switzerland, to Dignitas, for an assisted death, which is sometimes presented as the easy choice. I'll just jump on a plane. It's really, really deeply traumatic for people to do that. And often they do it alone because they know that their families face prosecution, potential prosecution if they do that. So it's a very difficult experience, and it's clearly hugely inequitable in that it costs a lot of money to do that. And the other thing we have to accept
I ask you
is...
to keep your answers quite short, because we've got a lot to go through.
Apologies, Chair. So their voices are really important.
Yes.
And the other point that you ask, Baroness Hedge, is, this is not the new thing that we think it is. Obviously, it's in this country, but there are countries who have been delivering safe, compassionate, assisted dying laws for quite some time. So it's really important that we hear from international experts who've got the experience of delivering this and giving those terminally ill people the choice that they deserve and need.
Could I just add one thing? The international experience. What the international experience shows is two things. First, introducing terminally ill assisted dying law vastly improves the experience of death for a number of people. And secondly, the safeguards work. Very many countries in the world, and I draw your attention particularly to New Zealand that just issued a report in November 2024, Western Australia, Victoria, focus heavily on the question of whether or not there is coercion in relation to this, and they indicate that there is not. The countries that have done it over a long period of time, and I draw your attention to Oregon, has produced annual reports that identifies no problem with coercion. The most moving thing about the international evidence is how much it improves the experience for so many people.
I'd like to take you up on one thing, which is about the coercion, whether they measured that. But also one of the other issues that have been raised is about whether it could be particularly vulnerable groups such as the disabled or people with other difficulties. How have the international, when you've spoken to them, have they discovered that there is that issue, and how have they dealt with that?
Well, there are two groups there. First of all, disabled people. Disabled people, in my experience and international experience, want to be treated the same as everybody else in relation to the option of an assisted death. There is absolutely no evidence from abroad that there is a particular problem in relation to disabled people. In relation to people with various learning difficulties or autism, again, with proper assistance, they too can have that option, but special care has to be taken. But that care can be taken, and the option is available to them as well.
Well, I have to move on to the next question, if you forgive me. Baroness Berridge.
Thank you, Chair. I declare an interest of assistance received as a donation from Dr. John Etherton. A question for you, Lord Faulkner. The first level of safeguards is, of course, the criminal law. So could you turn to the bill at clause 34?
Yeah.
Lord Faulkner, do you agree with me that when a criminal judge comes to direct a jury in relation to an offence under clause 34.1 relating to pressure, that there is nothing in your bill requiring a guilty mind on the part of the offender?
Correct. Well, the bill requires somebody, in order to commit the offence, by pressure to induce another person to make the first or second declaration. So if there is something which a jury regards as pressure, and I think juries are capable of defining what is pressure, then the offence is committed. So what this clause is doing is saying it's a crime to, as it were, pressure somebody so that their free will is compromised.
Yes, there are two people mentioned in that clause. A person, the offender,
Yeah.
who by pressure induces another person. That is the victim. A person. Where is the language of mens rea, Lord Faulkner, in relation to the offender in your bill?
Well, I think it makes it an even more strict offence if there's pressure without the offence is completed where there is pressure.
So are you accepting, Lord Faulkner, that you are introducing a strict liability offence into the criminal law with a sentence of life or 14 years imprisonment?
Yes, I am. And it's the same as the current law in relation to assisted suicide.
Can I just add on that point? I think the other really important point is that those offences don't exist at the moment. So if I think about a gentleman who gave evidence at committee, Pat Malone, he had a brother and a sister, one who went to Dignitas, one who took their own life. No one was checking for coercion or pressure or dishonesty in those instances. This provides a legal framework which at the moment just doesn't exist.
Yeah, thank you for your answers. Can you confirm, Lord Faulkner, is it correct that there is currently no other criminal law statute in England and Wales that uses the word pressure as the actus reus, and it is not defined in your bill?
I can't think of one. As I said before, pressure is a phrase that people understand, and I think that a jury would be able to understand what is meant by pressure.
If I can just add as well, we took evidence on the committee and the Commons about this, and it might be that the Minister from the Department for Justice can help with this because we had a long debate about those words and those terms.
Do you accept that it is usual in pre-legislative scrutiny to look at defining in law a word like pressure before introducing it into our criminal code?
I think sometimes yes, sometimes no. I think you'll find that when you've got the Commons and the Lords debating an issue like the word pressure, as Kim has described, the Commons looked at it in detail. I think the Lords would be very able to look at the question of whether pressure is the right word.
No, we'll have to move on to the next question. Scott.
Thank you. And firstly, can I just turn to the issues in relation to safeguards, because I think you've said that these are very strong safeguards, and particularly in relation to judicial. And I think you are both fully aware of the really quite extensive exploration and criticism that's been made by Sir James Mumby about both of these areas, first in relation to the Commissioner and secondly in relation to the panel. And just for the purpose of clarity, can I say that I am persuaded and adopt the concerns that he has set out. But I just want to take you through them, because I think one of the issues you've made plain is that you believe that there is a judicial safeguard.
Sorry, what, he believes there is a judicial safeguard?
No, the assertion is that you have said, and you said it just this morning, that the safeguards are robust.
Yeah.
They're stringent.
Yeah.
And I want to explore that with you, because this panel, which has now been introduced, is not a judicial panel.
It's not a judge, yeah. I mean, the decision was taken following evidence given in the committee and the Commons that actually having a multidisciplinary panel with the oversight of a judge through the Assisted Dying Commissioner, not acting as a judge, you're absolutely right, and that was the decision that was taken based on the evidence. But to bring in that extra level of multidisciplinary expertise with a social worker and a psychiatrist and a legal expert was seen to be much more robust than having one individual set of eyes on these cases.
But no one on the panel is being asked to perform that judicial process.
No, it's not a court.
There is no cross-examination, no introduction of evidence. There is no other side.
It's not
Families
a court.
can't come in.
Well, they can be asked to come in if the panel wishes to. They can speak to anybody they want to speak to.
There is no obligation.
No, because the decision was taken in the Commons based on evidence from ex-judges, including in James Mumby, but others as well, who take a very different view to him, that actually the judge wouldn't be the most patient-centred approach to this process. So the patient will go through the two doctors with a compulsory psychiatric referral if it felt necessary.
If you look at the
they
process,
will then be assessed by the social worker, the psychiatrist and a legal expert, all overseen by a voluntary assisted dying commissioner. So the number of professionals involved in the process now is far superior to having one set of eyes through a judge. And it also makes it much more compassionate and patient-centred rather than putting a dying person before a judge and a court.
The process has to be one that the public can rely on.
Absolutely.
That this is something that is not going to be pursued unless there is clear evidence. And from the panel's procedure, we have no idea as to how they are actually going to do it. It says may. There's no obligation on them to test.
They have to hear from the patient. They have to hear from the
They
patient.
have to
I'm
talk.
to interrupt you, I'm afraid, because we have to move on for time purposes.
Well, can I just then say that I very much would suggest to you that the process that has been adopted by the bill does not comply with any process that we would normally appreciate as being robust enough to do that.
And I would respectfully say the process as set out in the bill is far safer than what is going on at the moment because there's no checks. And by adding all those professional eyes, that's got to be a positive
We have to
thing.
move quickly. Lord Goddard.
Thank you, Lord Chairman, and declare my interest as Vice Chair of Dignity in Dying. And probably it's a two-part question to the pair of you. We hear a lot about the so-called slippery slope. So what makes sure the courts will not intervene and demand revision of the law, perhaps on the grounds of equality, as has happened in Canada? And also, as this debate's been developing this morning, you are on record as saying this is the safest and strongest bill in the world. And can you just amplify what gives you that confidence to say that, just make that statement, which is quite bold?
In relation to the first bit of the question, can the law which Parliament passes be changed in some way, for example, under the European Convention on Human Rights? I am completely satisfied that it cannot. I am backed up by that, by the human rights assessment that the government, not myself and Kim, but the government independently have made. The reason I am so convinced that that is right is because what the European Court of Human Rights has said is assisted dying is quintessentially an issue for the parliaments of each of the member states. Very senior judges in the UK have repeatedly said that as well and said it's for us to decide. In the debate at second reading, a Conservative peer suggested, well, wouldn't the 6-month cut-off, you've got to have a diagnosis of 6 months of terminal illness, be something that people might say is discriminatory? No, it is so quintessentially a policy issue. There are 7 assisted dying laws in Europe at the moment. All of them have existed without being changed at all by the European Convention on Human Rights. Parliament will decide this question, and it's right that Parliament do decide this question. So I'm completely satisfied, as is everybody else who's looked at that is safe in that respect.
Yeah, and if I can just add to that, I would concur with what Lord Faulkner said, that the ECHR memorandum confirmed that the bill is compatible with the ECHR, and that came from the government. I think in terms of safeguards, I would kind of reiterate what I've said already in terms of the lack of safeguards that exist at the moment. And if we look at the legal framework that the bill sets out, we have 2 independent doctors. We have a multidisciplinary panel including a legal expert, a psychiatrist and a social worker. We have judicial oversight through the Voluntary Assisted Dying Commissioner. We have 5 separate assessments of the person's eligibility. There's a requirement that the person is given all options that are available to them in their dying days. We have a compulsory psychiatric assessment if either doctor has any doubts about the person's capacity. We have access to independent advocates. We have a disability advisory board. We have new criminal offences, including around coercion. We have specific training on mental capacity and on identifying domestic abuse, coercive control, financial abuse for all doctors and all panel members. And we have rigorous oversight and reporting mechanisms requiring the involvement of the chief medical officers and reports to Parliament. None of that exists at the moment. So in terms of safeguards, am I clear that this would be the safest piece of legislation in the world? 100%.
And you just referred to slippery slope.
Lord Faulkner, I have to move. Lord Winston.
Thank you, my Lord Chairman. I want to have a question for Lord Faulkner. You've talked about experience in other places, and this committee has a responsibility to see if this bill could be made workable. Many of its opponents argue that it's flawed, and of course it has flaws which can be changed possibly. I wonder whether you feel that it is really quite important to see evidence from other countries, because there are so many who are doing this for a long time, who have great experience. And how would you suggest that we could improve this bill by accepting such evidence from other legislations?
The foreign jurisdictions that have introduced assisted dying bills are wrestling with exactly the same problems that we are wrestling with in relation to this bill, in particular capacity and safeguards. They're not the only problems, but those are the two main problems that one is looking at. If one looks at the terminally ill bills across the world, they've dealt with that issue in a variety of ways. The best way to look and see how they've done is to see the independent reports that have been produced in very many of these countries after such legislation was introduced. So, for example, Oregon every year produces a report. For example, and I know the Bishop of Newcastle will be conscious of this, the New Zealand state introduced after 3 or 4 years of its assisted dying bill a full report in relation to it. For example, New South Wales produces a report every year about how its bill is getting on. For example, Western Australia produces such a report. I strongly recommend, first of all, that the committee draw some evidence from abroad, because they will be addressing the same issues. Can I give you an example? Clause 5 of this bill allows a doctor, subject to his or her criminal judgment, to introduce the issue of assisted dying with a patient, but in the context of making sure all options are made available. Both in relation to New Zealand and Victoria, the question of what is called the gagging clause arises. The gagging clause in Australia, in Western Australia and New Zealand, is should the position be that the doctor cannot raise it unless the patient raises it. In New Zealand, a report has just been produced by the Ministry of Health in New Zealand where there is a gagging clause, the doctor can't raise it, and they say maybe that's not the right conclusion. That is an example of an issue which our House will have to deal with, where looking abroad can really help you. And I think there's a number of people who would be very keen to give evidence, who would provide you with real assistance in relation to that.
I would 100% agree with that, and we can provide a long list of names of people who were happy. I mean, we had multiple international experts give evidence in the House of Commons. Dr. Ryan Spielvogel from California, he actually is responsible for the training of all the doctors and the medics. We've got Claire Fellingham from Australia, Ben White, another Australian doctor, and they've been involved in setting this up, monitoring it, training the medical people involved, and everything around it. So their voices, I think, are really, really important.
Thank you very much. Lord Goodman.
Lord Faulkner, could I ask you to turn to clause 27 of the bill, which is approved substances. So, in relation to approved substances, the Delegated Powers Committee, in which I sit, recommended a definitive list of substances on the face of the bill would, and I quote, facilitate an expert debate and generally be in the interests of clarity and transparency. Now, at second reading, you explicitly ruled out such a change because you said, I'm sure this is correct, advances come thick and fast. But why shouldn't such advances be addressed later by regulation after Parliament has initially discussed and debated which substances should be used? Why shouldn't we debate that on the floor of the House?
I can think of nothing worse than politicians deciding what drugs to use. I think the right course is for a proper body to decide that. The idea of a bunch of politicians deciding that seems to be wrong.
I would agree with that, and that was certainly the same in the Commons. I mean, we have 650 members of Parliament. I think there are a handful with a medical background, and they are brilliant, but for a number of reasons, for lots of other people to have that discussion wouldn't seem the right approach.
All right, so it's absolutely clear you disagree with the Delegated Powers Committee, which had people on it with all sorts of different views about the bill, that the matter should be discussed on the floor of the House. So let's just leave that there and turn to clause 37, if you wouldn't mind, which is about the regulation of approved substances.
37.
37, yeah, 37. Just 10 later. The committee pointed out there's nothing on the face of the bill about the following: the power to create criminal offences and penalties, civil sanctions, investigatory and enforcement related powers. And if I'm correct, the Secretary of State would have the power to amend primary legislation. The committee said this is, quote, highly inappropriate, which is pretty strong language for a committee. So will you be tabling amendments stating what such offences, penalties and powers will be, guaranteeing that the substances will be safe, efficacious and not cause suffering?
Yes, I agree with on that point, and as I made clear in the second reading, I hope, I think there are changes we can introduce in relation to clause 37, in which we're deciding what the purpose is and the points you just made at the end. So I agree, changes are required in relation to that.
You'll yourself be tabling amendments to that effect. I myself
will be making proposals in relation to that. And I regard although I strongly disagree with the first proposal you made in relation to clause 27, and will say that on the floor of the House, as is very normally the case with the House of Lords Delegated Powers Committee, they're an important, worthwhile committee. We will draw on what they're suggesting in many of the respects that you've identified in clause 7. Thank you.
Baroness Finlay.
Thank you. Could I ask both of you, but then I've got questions for each. And I should declare that I'm a non-remunerated director of Living and Dying Well, and I have had some part-time research support in relation to this bill from there. This bill has been promoted on the basis of a solution to severe pain and suffering. You've spoken about other countries, other jurisdictions who do include suffering in their legal definition. Why did you choose to not mention either pain or suffering anywhere in your qualifying conditions? And if I might just also pursue your comment about the reports, are you happy with Oregon destroying all of their evidence after 1 year so that their reports are produced often with many gaps in data and there can be no research into the data provided to them? And then the other question that I would like to ask in relation to the panel is why there is no appeal mechanism in the event that somebody feels that an approval for lethal drugs should not have been given. There is only an appeal mechanism against a decision to not provide lethal drugs.
First of all, suffering. The essence of the bill is autonomy. So you have a choice. We did not take the view that it is appropriate to have as a condition the suffering of an individual, which is a subjective matter. Can I answer the question? Once you satisfy that requirement, then we say that, there's obviously the safeguards have got to be complied with, but that's the essence of the bill. It is autonomy. Secondly, destruction of records by Oregon. It's for Oregon to decide what the position is. The key thing about the Oregon reports, which come every year, is they indicate absolutely no problem whatsoever about coercion. I can't remember what your third question was.
I'd asked you about the appeal mechanism in relation to panels.
You have to have a system that can work properly in the context of somebody who is dying. What you do not want, if you want to make this work, is some inflated court process.
When you talk about the Oregon reports, 58% of people cite feeling a burden. And feeling a burden is a common feeling amongst patients, particularly when they are subject to different pressures, such as worrying about finance and so on. So I'm concerned that you have not allowed for that, either with suffering or with pain, and you talk about choice, but if there is no service there to deal with somebody's pain, then they do not have a real choice.
You know from those reports, because you've read them, that the three items that people most cite in Oregon are, first of all, a lack of autonomy, secondly, a lack of dignity, and thirdly, pain and suffering. The item that you referred to, feeling a burden, is I think something like 6th or 7th, and is one of a number of items. The key thing for us is the choice.
Can I just add to a few of those points? In terms of the phraseology around suffering, this was a very conscious decision on my part because of conversations I had with disabled people, and they had said to me, you know, particularly disabled people who are supportive of a change in the law, they wouldn't be keen to support a change in the law if it included the word suffering, based on their lived experience of how they had been treated by essentially people saying to them, you must be suffering, your life must be awful. I mean, that's just dreadful. So I was very clear that the terminal diagnosis and the 6-month prognosis were the criteria that should be in the bill. And that was also, as Charlie said, suffering is a very subjective concept, and it should be the autonomous right of the patient to choose if this is what they want to choose. In terms of reporting, I mean, I agree we need really strong, thorough reporting, and that's why the mechanisms in this bill are there to make sure that all these cases are logged, everything is reported, we've got robust data, and that's really important. In terms of the concept of someone feeling a burden, I think it's a really delicate conversation to have, but it's a really important conversation to have. One of the doctors from California said that as soon as a patient mentions that word, it's considered a red flag. And they explore that conversation. They explore why the patient has said that. These are not quick conversations with doctors. They're very detailed, very patient-centred conversations, and it's very, very important, as the bill sets out, that this is the patient's clear, settled and informed decision. So every aspect of that is examined throughout the process.
Can I come back on that slightly and ask you then why in your committee you accepted the statement that a doctor should not be asking a patient why they want to die? And that's clear, that's in the record of your committee. And yet asking a patient why they are distressed is a fundamental step in all diagnosis, in all good medical practice. And that would suggest, I just wonder then why you feel that this process is a medical treatment and why it shouldn't be completely outside clinical medicine.
Well, it's not completely outside clinical medicine. But there's two different questions there. I mean, asking someone why they want to make this choice is a different question to asking why they feel distressed. And clearly, if a patient is distressed, that is something any doctor would explore and want to have that conversation about.
But if you're exploring why they want this choice, you have to understand the background to it.
Absolutely. And you would ask them lots of questions about how they're feeling and lay out the options to them. So they're very detailed conversations. And they're also conversations, as doctors on the panel and others have said, that doctors have these conversations at the moment, and they're very, very good at having those conversations. It's a very patient-centred approach. And again, when you hear from international experts, they will tell you this is the most patient-centred piece of their work. And it's very, very personal. And those conversations are very detailed, and they're very patient-focused.
I'd like to move on to Lord Markham, but before I do that, I'm afraid I cut Baroness Berry short and also Baroness Scotland. I'd like to give you both a chance to come back once we've finished Lord Markham. Lord Markham.
Thank you. There is a concern that the committee might not hear from the people that this bill is about, the terminally ill. As the bill sponsors, I was wondering if you could represent their view in your replies if they are not given the opportunity to speak to this committee.
I mean, the two purposes of this bill is to make the experience better for people who are terminally ill and for those who are left behind. Not to hear from them is not to hear from the driving purpose of this bill, but in hearing from them has got to be extremely conscious of the need for safeguards. One would be very, very surprised if any committee gathering material didn't hear from them.
Yeah, and I would say it's just fundamental, isn't it? You know, if we were passing a piece of legislation about violence against women and girls, there's no way you wouldn't hear from victims and survivors. In the same way that we're passing a piece of legislation about terminally ill adults, and the title of the bill is very clear in that regard, then of course you must hear from those people, and you must hear from the families of people who have lost loved ones, and will give very clear evidence of the failings of the status quo and why the law does need to change. And I've met with lots and lots of those families. I'm very fortunate. I haven't been affected by this issue on a personal basis, but when you've spent as much time as I have with people who have, and indeed people who are in their dying days, who know that this law will not come into effect in time for them, but they are still campaigning because they don't want other people to not have that choice and the dignity that this law would provide for them. And also, you know, I've spoken to families who have faced that fear of prosecution, and I think Lord Faulkner referred to Louise Shackleton. She was the person who went with her husband to Dignitas after the second reading of the bill in the Commons. She wrote to me after that with a very long, very, very emotional email of what that experience was like, but also the threat that hung over her then for months. And I've met lots of those people as well. And people are dealing with loss, grief, bereavement. They should not be dealing with the fear of a prosecution on top of that.
Thank you. And similarly, there's a concern that we might not be able to hear from international people who face similar things. So coming back on the questions on around safeguards and whether there should be a judicial process around that. Again, I was wondering if you could maybe tell us some of the international experience that they have in this place where they're not using a judicial process.
As far as I'm aware, with the possible exception of Spain, where there is a committee process, no other country has the sort of regime that we are proposing in this bill for a panel to look at the matter. In relation to practically every other country, it is primarily doctors who've got to make decisions. There are doctors who have to be supported by an independent doctor. That, for example, is the position in relation to New Zealand. But the idea of the panel, I can't say it's completely unique, but we are one of the very few countries that assume it becomes the law have such a proposal. And what that involves is a senior lawyer or judge, a social worker and a psychiatrist looking at it, which is an added safeguard.
Thank you. And I know a number of people have expressed a concern about the palliative care impact of such legislation coming forward. Again, I was wondering, based on your experience and the international experience, what's happened to palliative care in these examples?
Practically everybody who has looked at this issue, and I have in mind the state of Victoria in Australia looked at this, the Select Committee in the Commons, which did a 14-month inquiry, which reported in 2024, looked at this. They said the following: in no country has palliative care gone down as a result of assisted dying, and in many cases it's gone up. In this country itself, the Secretary of State for Health announced a further £100 million for palliative care after the bill was introduced. The Chief Executive of Hospice UK said publicly that the reason for the increase in funding in the UK was as a result of the introduction of the assisted dying law. I think one can be pretty sure that the effect of an assisted dying law is to make people debate the way one dies more. The consequence is that's a much greater focus on palliative care. That leads to greater resources coming to the palliative care regimes. Take, for example, Oregon, where Oregon, which is the first of the American states to do it, palliative care was quite low down in its standards when it started. It's now in the top group of palliative care providers in the United States of America.
Thank you. And then finally, in terms of mental capacity, again, there are other concerns about whether people have mental capacity to make the decision. Again, I would welcome your thoughts on the safeguards that you built into the bill.
What we're proposing in the bill is that you use the Mental Capacity Act in relation to that. There are various people, and Baroness Findlay is one of them, who've made a proposal that we have a completely different form of mental capacity check for this. I disagree with that strongly. I think the Mental Capacity Act has proved a very robust framework in which decisions are made about medical issues with the assistance of doctors. Sir Chris Whitty, who I think you may be hearing from, he gave very powerful evidence to the Commons Bill Committee saying the Mental Capacity Act was a very robust and well understood method of determining the capacity of patients, and he strongly supported it being used in relation to it. The Mental Capacity Act at the moment determines the capacity of patients who've got to determine, for example, whether they want life support to be stopped. To have two separate regimes, one for this bill and one for major decisions like this, seems to me to be confusing and completely wrong. We strongly adopt the views of Sir Chris Whitty in relation to that.
Thank you.
Baroness Berridge.
If I could just begin with the question I would have put to Ms Ledbetter and give you time to look at the legislation. Clause 43, we prohibit advertisements. There is no definition, though, in the bill of advertisement. So that word does not include what young people view through YouTube influencers, TikTok videos, video games, or artificial intelligence, including ChatGPT. So are you not concerned, Ms Ledbetter, that we are opening up and parents might not be aware of messages and promotion of this that is not caught by your clause. Whilst you look at that, the final question I had for you, Lord Faulkner, in relation to our strict liability offence. So if a doctor or nurse is stressed because they need to pick up the children, they missed a night's sleep, enter the room and bring pressure with them subconsciously into that room that the relatives then say it was as a result of that, they self-administered, are you saying that the fear of prosecution with life imprisonment should hold over that doctor or nurse on a strict liability offence?
On the advertising clause, this is a really good example actually of cross-party working on the bill. So this was an amendment that was originally proposed by a colleague who is not a supporter of a change in the legislation but wanted to see something around prohibiting advertising, and I fully supported that. So we worked quite closely on that, and then we got legal advice from officials around that. But Lord Faulkner and I are doing some additional work on this because I think you raise a really valuable point that, you know, I was always very clear it would be inappropriate for services for assisted dying to be advertised. That would feel wrong, but we're still working on the detail of that and be very happy to provide updates on that.
So could you, when you do your updates, consider any impact on the online safety bill? And you say, Lord Faulkner said that this is a well thought through piece of legislation. I don't think that parents will agree with you if we are still having to look at matters like those advertisements at this stage, would they?
Well, I think the other thing I would say is this is a terminally ill adults bill, so young people would not be eligible under this bill, and again that's something I was very, very clear about. So I think it's a fair point to talk about advertising, and I'm very happy to continue those conversations and work together if that's helpful.
Thank you.
And your point about that it's not a well thought out bill because we haven't fully worked out the ramifications of online advertising. I think that is a criticism that could be, it's not a criticism, that is a point that could be made about the way that online adverts and online influence happens right across the board. And I think society is wrestling with that in a big, big way. We are wrestling with that as well in relation to this, in the form that we are trying to come back with more detail in relation to advertising. But I don't accept the criticism that because we haven't solved the problem of online advertising in this respect, that it's not a well thought out bill. In relation to your other point about pressure, we were extremely keen that the thing the safeguards have got to do is to ensure that the person, when they make a decision about whether or not they want an assisted death, do it free from pressure. It is their own decision. Therefore, I don't apologise at all for having pretty fierce offences to ensure that.
Anna Scotland.
Thank you. Can I just take you up on a matter that you referred to in your statement? You said the current law on assisted dying contained in the Suicide Act of 1961 is not fully applied by the DPP and provides no safeguards and is often cruel in its effect. I think you'll be more than conversant with the guidelines, the DPP guidelines that came out in February 2010, which were highly consulted upon and indeed received a lot of applause for the way in which they were undertaken. Would you like to qualify the statement, therefore? Because if we look at the data since those guidelines came in, we have had only 191 cases reviewed since 2010, that's over the last 15 years, that 133 of those were not proceeded with because a proper decision was made that it was not justified, that 10 are ongoing, only 5 were prosecuted, and they were prosecuted in relation to serious offences, which is concerns in terms of homicide or serious crime. Now, I'm sure you as a former Solicitor General are not suggesting that the DPP, with the oversight of the current Attorney General, is not properly applying these principles to enable those who are responsible for offences to be dealt with. And so what I'm going to ask you is this: how do you propose that under this bill we will deal with those cases where improper pressure has been carried out, and how is that analysis going to be made? Are we going to have the official solicitor? Are we going to have to have the Attorney General's panel? How are we going to do it? Because that is a mischief.
First of all, your first point. The law in the 1961 Act is that if you provide any assistance to somebody to commit suicide, including in the context of terminal illness, you are committing a serious criminal offence. And the choice made in the 1961 Act is unequivocal. It does not matter what your motivation is. You are guilty simply by providing the acts of assistance. So, for example, if I buy the air tickets to fly my spouse to Switzerland, knowing that he or she is going to commit suicide there, then I'm committing an offence. Can I just answer the question first? In relation to your question, the effect of the guidelines of the DPP is that despite the fact that the law is unequivocal in that respect, he or she has introduced a defence in effect. That defence is, if you are motivated by compassion and you are not a medical person, then you will not be prosecuted. So, in effect, well-meaning officials, and then they are not breaking the law, the well-meaning officials in relation to this, but well-meaning officials are indicating that they are not going to apply the law in its full rigour, as they are entitled to do. But can I just please let me finish? Because the important point to make is that the DPP does not think that the law in its full rigour can be enforced. And I suspect the reason he's thought that over the time is that no jury will convict where there is compassion. Sorry.
Can I just, you know, as I do perfectly well, there are two tests. One is whether the matters complained of are found. The second test for every prosecution is whether it is in the public interest to prosecute. So that is not failing to implement the law. It is implementing the law in accordance with the prosecutorial practice that we apply to every single case. And the Suicide Act is no exception. So that the guidelines that the DPP puts out in relation to a number of offences will always take those two tests into account. So do you accept that it is quite wrong to say somehow that this is an amendment of the law, because in fact it's the fulfilment of the law by the officer, the legal officer, who has to make that decision as the guardian of the public interest?
Well, I'd be very, very surprised if there's any other identified case where you could say the public interest introduces a defence not in the Act.
Can I just make two very quick points on that? I think for me, as a non-lawyer, when 4 former directors of public prosecutions say that the law needs to change, I think there's very clear evidence that the law needs to change. And can I also just come back to the person at the centre of this? In the middle of this, we have a dying patient. We have someone who has not got long left to live. I understand we have to get the legalities of this right. Absolutely right, I understand it. But why would we put that person and their family and their loved ones through a potential prosecution, even if it is only potential prosecution? Why would we do that to them when we can change the law to make sure that they are not subjected to that?
We have a few minutes left. Does any member of the committee...
Thank you. One of the arguments made in our second reading debate, I can't remember, I think on the 12th of September, was that you've overdone it, that there are just too many safeguards now, and it's going to be almost unworkable. So can you, particularly Lord Forsyth, I think, but there may be others, can you give some reassurance that you haven't so overloaded this that actually no one's going to be able to get through it?
I think that's a really fair and difficult criticism, because it's something I really wrestled with. Again, thinking about the people who the bill will be there for, these are people who have got not very long left to live, and we have asked them to go through what is in reality quite a lengthy bureaucratic process, and it was Chris Whitty, Chief Medical Officer, who said we must try and avoid a bureaucratic thicket, and he also said that sometimes the safest safeguards are the simplest. I have wrestled with that, and I've been contacted by people who have got terminal diagnosis, who have said, goodness me, Kim, we're already going through so much, and you'll have to go through this process, which could take up to 2 months. That is difficult, but I would also come down on the fact that it does need robust safeguards, and the bill provides robust safeguards. But I take the point on board that, for some people, and this has happened in other jurisdictions, they will sadly pass away before they go through the whole process. But is it better to have a really robustly safeguarded piece of legislation which puts things in place which just don't exist now? I think it is, and that's certainly the decision that I made.
And just to pick up on that, we've erred on the side of caution in relation to this, which is the right thing to do. I think a very significant issue will then be how it's introduced by the medical profession, and in particular the National Health Service. It's very important there shouldn't be an over-engineered process. If you look, for example, at the way the slimming drugs are being introduced, I mean, nobody's ever going to get one, basically. You've got to be careful about how it's introduced.
We're almost up to our time. Baroness Berger, a quick question, please.
Just had a quick question, and forgive me. You referred to the evidence given by Chris Whitty, but can I just for the record make clear that Chris Whitty had to retract some of his evidence relating to some of the points that you made. So, just for the record, you'll perhaps know the reports, and there was reports that votes were taken in the Commons that couldn't be changed, that would have been different had his correct evidence been given that he had to correct.
Can I give you the evidence I was thinking of what he said, and he didn't retract this bit? The Mental Capacity Act is used up and down the country by doctors and nurses every day. They know it and understand it. To practitioners like me, this is Chris Whitty, it feels like a piece of robust and predictable legislation. Having a system with two completely separate groups of assessment, and he's referring to withdrawal of care and assisted dying, one of which has never been tested in the courts or used out with this bill, that's referring to the sorts of proposals that Baroness Finlay is making, would lead to a whole set of potential complications and ambiguities which are not there at the moment because we have a well-tested mechanism through the Mental Capacity Act. I don't think he withdrew that piece of evidence.
Indeed, but what he did have to retract, which was the context and the points that he made, was that the Mental Capacity Act carried the absolute expectation the more serious the decision, the greater the level of capacity that someone needs to have, and he had to retract that.
Well, he changed the way he expressed himself, and I've got that somewhere amongst my many papers, and he did say that, but it is about the fact that the severity of the decision has to be taken into account when you're thinking about someone's mental capacity. So he did change his terminology, and I'm happy that that's on the record.
Well, I think we really have to stop it there because we've got another session coming up. On behalf of the committee, can I thank you both very much indeed for coming and for your evidence.
Thank you for having us.
Thank
But
you
I
very much
remind you,
indeed.
please, to check the transcript when it comes out and draw our attention to any errors you may find there. Thank you.
Very much. Thank you.
Welcome to the second session of our inquiry into the terminally ill adults end-of-life bill. We are joined in this session by Dr. Michael Mulholland, Professor Montas Patel, and Professor Nicola Ranger. You're all very welcome, and we look forward to your evidence. We'd be grateful if you could introduce yourself briefly in a moment, the first time you speak. Today's meeting is being broadcast, and a verbatim transcript will be taken for subsequent publication. They will be sent to you to check, and we'd be grateful if you would draw attention to any errors you may find. I refer again to the list of members' interests as published on the committee's website. I wonder whether Dr. Mulholland, you'd like to say briefly who you are and what your position is. Very briefly, please.
Thank you. I'm Michael Mulholland. I'm a GP in Buckinghamshire. We've been a GP partner for 28 years now, I think. I'm here on behalf of the Royal College of GPs, the membership organisation for 54,000 GPs in the country. I'm the Honorary Secretary and lead on clinical policy, and have been leading on our work on the assisted dying bill.
Thank you. Professor Patel?
Hello, my name is Professor Mumtaz Patel. I'm a consultant nephrologist by trade. I work in Manchester for many years, and for the Royal College of Physicians, I'm the president of the Royal College. Our college is one of the largest medical Royal Colleges of around 40,000 memberships across 30 medical specialties. Good to be here. Thank you.
Professor Ranger?
I am the General Secretary and Chief Executive of the Royal College of Nursing, that is both a Royal College and a trade union, and we represent over 500,000 nurses and nursing support workers and nursing associates. Prior to that post, I've been a chief nurse in hospitals for the past 10 years. My last clinical post was at King's College Hospital in South London, where I was the chief nurse through the pandemic. Thank you.
Well, unless you'd like to say anything else, I think the simplest thing is for us to proceed straight away to questions. And I'm going to ask Lord Patel to begin.
Thank you, Lord Chairman, and good morning, and thank you for coming today. The Lord Chairman in the previous, before we started the previous session, made a statement, which briefly was that this particular committee is looking to see how the legislation as it's come to the Lords could be made to work, or what is it that in it that may require amendments to change it. So in that context, first of all, can I declare an interest that I am an emeritus professor of obstetrics and gynecology, University of Dundee, that I'm a fellow of several of the Royal Colleges, most of them freebies given to me, but for which I am very privileged and grateful. So if I can get on to my question, and it's a brief question, and I'd like brief answers from each of you so we can follow it on. I know that you all now have a neutral position, and I know the College of Nurses were the first to come out of the block to adopt the neutral position, but now most of the medical Royal Colleges have followed that. So on the basis of that, what do you think is in the current bill that is good and workable as far as assisted dying is concerned? First question. Second, and please answer it in that order, what is it in it that you think will not work? And thirdly, more importantly, what is it you suggest that needs improvement to make it work? So can I start with you, Dr. Mulholland, first?
And could I ask you to be fairly brief in your question, because a lot of people, your answers rather, there are a lot of people who are wanting to ask questions, so as brief as you can.
Thank you, and thank you for the question. And I note you're an honorary fellow of our college, so very pleased to answer. As a college, we're pleased that patients are going to have the ability to make decisions for their own choice and their own health and their own death. And that's something in general practice we've always been keen on. And we have discussions as people approach their death as to where they want to die, how they want to, if they have that ability to plan in advance. And we have thought long and hard about it as a college. We moved from a position against to a position neither for nor against, but wanting to support our patients and our colleagues, because we recognise the divide across the country and in the profession as to those who are for, against, or the process. What we feel it still needs to be looked at is that we are very supportive of a separate service. We don't want this to be part of core general practice, and we want to see separate pathways that patients could go down if that's the case. And we will be asking payers to consider tabling an amendment to that effect. We feel that it's really important that the language of the bill is clarified a bit, and we would support Baroness Finlay's amendment to this, that opt-in is what we would like to see throughout the bill. We noted that it wasn't there in the impact statement or this impact assessment. It was called opt-out. So we just like it that if a health professional is going to be involved, it's an opt-in process, because we know there are many of our members as GPs do not want to be part of this. And beyond those are the key parts that we are wanting to draw your attention to that are concerns. We think if this bill is to be passed, the oversight and regulation of the process is essential, that those taking part, whether it's to assess capacity as discussed previously or anything else, those people will need extra training beyond what they have at the moment, and that it's open to all health professionals. It's not something for GPs just. Yes, we see our patients at that moment of contact primarily as the first people, but once we have signposted or directed that the service will be provided by specialists that are providing it. So it's not something that a GP, if we look at the numbers that have been suggested, it's around 3,000 patients per year, which if you divide that across general practice in the UK is about one patient per practice every 2 years. And we don't think that an individual should have that infrequent contact with it, otherwise they'd have to learn everything again, that this needs to be done, that people that are in that. Thank you.
Professor Patel.
Thank you. So again, similar to Dr. Mulholland, our position from the Royal College of Physicians is a neutral stance. However, we continue to have concerns around the practical elements of the bill, and particularly from a, kind of what is good about the bill, as you asked. Patient choice is always wonderful, and what we want to support patient autonomy around end-of-life care is really, really important. However, the bill as it stands, we have concerns around the deficiencies, particularly around a number of different aspects. So firstly, around patients should be enabled to have equitable access to all services around and choices around end-of-life care. And assisted dying is one aspect, but the breadth of end-of-life care. And then similar to what Dr. Mulholland mentioned, we have a lot of concerns from our clinicians, physicians, who wish to have that option of absenting themselves at any aspect of assisted dying. People are varied in their breadths of views around the principle of assisted dying, but with regards, again, the practical implementation, they should have an option to absent themselves. And then around decision-making. Decision-making is complex. We have a number of patients, or all of our patients, with complex medical needs. And what we're saying is that, with the bill as it stands, the decision-making is very much made in a multidisciplinary form, and with shared decision-making and with clinicians involved in their patient care. And that is currently not clarified within the bill as it stands. And then prognostic uncertainty, that's something that we grasp with day to day. And around whether it's 6 months or different, but it's so hard to certainly, kind of make that very clear, that prognostic uncertainty to both patients and their families is made very clear and understood in that way. Decisions around capacity, safeguarding, particularly our vulnerable patients. Health inequalities are already there for a lot of our patients who are disadvantaged, and we don't want this bill to exacerbate that. And then lastly, I guess, is around services being regulated, monitored, whether it's the service itself, put together also with the prescription of the medications. And then assisted dying as a service should not preclude and divert resources from the wider equity of access to all forms and services around end-of-life care. So a number of things that we've put within our position statement that we presented in Parliament. This was a position statement from the 9th of May, and subsequently we had a further position statement.
We all have had the statements that each one of you produced, but I would rather you focus on the question asked. So can I move on to you from College of Nursing?
Yes, thank you. I mean, I think very much agreeing with what my colleagues have said. I think we think it's good that at least people are going to get the opportunity to have some degree of stating what is right for them. We do within that, though, we are neutral, but recognise that nurses, some will feel very strongly they want to support assisted dying, some will not, but we will support that individual clinical decision-making. So we're pleased that this is at least people, both clinicians and the public, will get an opportunity to start to getting a sense of what they want. What we're slightly worried about is we think there's got to be very, very clear language and clear separation between palliative care and assisted dying. They are two separate things, and we worry sometimes those two things get muddled. And we've got to be really clear about that, with the primary issue being that palliative care is a dignified death and pain control for everyone, but obviously assisted dying, the premise primarily is about autonomy, and I think those things need to be very clearly distinctive. I think the other concern that we have is that we totally appreciate how this has come about, but for many, many patients or public, the first person they will talk to is a nurse. That is the person they will talk to at 2 o'clock in the morning when they're concerned about things. That is the person they will often have a conversation with in their own home or in a GP practice. And what we want to make sure is that nursing and its contribution is fully appreciated within this bill, because many of the leadership is with the Chief Medical Officer, and rightly so, but I think it's important to see the majority of end-of-life care now is delivered by nurses. And I think going forward, if someone is an opt-in around seeking assisted dying, they will often have that conversation with a nurse, and we think it's key that is recognised within the setup. And I think there are some challenges around. We absolutely agree with safeguards, but I think it's really important that the public have confidence in the process. It has got to be fair, and it's got to have scrutiny to ensure there is no coercion, there's safeguards, but it can't be so complicated that the principle of autonomy is lost in this. And so I think there's some key things to really focus on.
Thank you very much.
How would you, does the bill cover the involvement of nurses, and where does it not?
Pardon?
Where does the bill do not cover the involvement of nurses?
I think it does, but I think things like the setup of a panel, it's some are feeding in some people who know the patient, know the family, spoken to them. I can see the panel process, but it's how do you get a full rounded picture with regard to decision making, and I think it's key that that's
stop you there, I'm afraid, because we've got to move on. A lot of ground to cover. Baroness Berger.
Thank you so much, and thank you for joining us today. The two questions I'm going to ask about are one around training and one specifically around family and carers related to the person involved. So my first question is, in all of your submissions that you've previously made in the Commons, you've talked about the importance of detecting coercion, and the RCN has also talked about the importance of clear safeguards. The Royal College of Physicians has explicitly supported the amendment tabled in the Commons to introduce mandatory training on domestic abuse, including coercive control and financial abuse. And I note that Professor Ranger, you've raised concerns that nursing staff are not currently included in this requirement at all. So my question to you all, on behalf of your members, is do you believe that the current training requirements set out in the bill and referenced in a bit more detail in the impact assessment are adequate to ensure that coercion and abuse will be spotted? And if not, what changes would you and your members like to see?
I mean, I think that there's something around. You can never say it's always spotted, because sometimes people make mistakes. I think it's the principle with regard to safeguarding that has got to be hammered home. Is safeguarding is not proof; it's raising concerns, and actually you'd rather have a high threshold to raise concerns that it's looked into than assuming you have to have the evidence before the safeguarding alert is made. Safeguarding is a neutral act, actually, and I think sometimes people don't always see that. So with any education process, it's absolutely key that that is to all clinicians made absolutely clear that safeguarding, if you have a concern, you just have to report it. You don't have to prove it. That's someone else's job, and I think that is really important in education.
Thank you. So agree with that point, and I think specifically education and training. We have mandatory training for a lot of these things from our overall clinical practice, but specifically around safeguarding for coercive control, together with protecting our vulnerable patients. These are concerns that are very much raised by our members and fellows, and feel that the current bill in its state, that training element is one aspect. And as you said quite rightly, raising the concern, you'd think that's fine, that's one part of it, but then what next? And then how would you manage that? And the follow-through isn't well defined, and that's one of the things, again, with regards to practical implementation of this, is a real concern for our members as well, and similar to what you've said. So training may address in part, but then it's the follow-through as well.
What would you like to see better defined? Forgive me.
Well, I think better defined as in, kind of the specific aspects around the vulnerable patient groups, what kind of training would be initiated, who would do what assessment, because again, currently as it stands, I think, kind of the assessment aspect side of things, face-to-face requirement, I think we've emphasised that within our statements, that should be done by well-skilled, appropriate staff. And then the decision-making around the what next after things are identified needs to be then done as a sort of an MDT team assessment to what the next steps are. And that's not defined.
And I think there's a practical bit to that in reality. If someone is seeking that sort of wanting to seek assisted dying, from a clinical point of view, when patients say, just asking what gave them that initial thought. If the suggestions come from somebody else, that's a red flag. It's just being really, really clear. This is about self-determination, not someone else's suggestion. So I think that would raise a red flag in a practical way if someone has suggested it to an individual. That's coercion.
Thank you. I think as GPs we're very used to providing holistic care, trying to understand where the patient's coming to us from in lots of situations, and are aware of the challenges sometimes particularly our elderly face when coming and you think, who's behind this question you're asking me? So we're used at that level to making decisions and weighing up evidence. We have toolkits available from the RCGP for GPs on safeguarding that addresses coercion already. I think if this bill was to come to pass, we'd be updating it for the assisted dying as well. However, we're not the only point in that chain. And I think at every point a patient moved through a process, coercion would be something that would have to be high in the minds of the clinicians or the people involved in that, with specific training for those as they get closer to the point of a decision about assisted dying. Some of the things that have made a difference to us over my career have been that in maternity notes now, it's an automatic prompt when I'm doing an antenatal questionnaire or a postnatal check to ask a woman about, are they safe at home? How's the relationship with their partner? To assess the risks of domestic violence. And I think we would need to develop tools similar to that to be in the place if we were having assisted dying conversations. You would want to make sure it was recorded at every point that people were thinking about this on the way through.
Give me just on training, but as you'll be aware from the impact assessment, that the total amount of time for training on this, and I take on board your comments about how you'd like to have GPs removed, but on the basis that we progress as the bill is as presented, that the entirety of the training will be just 2 days for the coordinating doctor and 1 day or even 2.5 hours for everything for others, including GPs. And I wondered what you think about that.
I think there have been estimates of the time involved in taking patients through assisted dying in other countries, and it's sometimes up to 30 hours or more of a doctor's time. And so to be able to provide...
This is about the training for your members, not...
And so I was going to say, to be able to provide that level of care and understanding in many other areas, I have significantly more training. So I think we'd want to make sure that it was appropriate for those doctors that are most involved. For a GP that doesn't want to be involved in their signposting, they would need to know the basics of it. So I think it will vary significantly depending on which level of care someone is providing.
Thank you so much, Chair. I'm conscious of time, but I did want to ask about the involvement of family members, and particularly cognizant of the evidence and representations made from the Royal College of Nursing, and the point that you just made about your members often have those conversations with patients and their family members and carers. Can I just ask you if you, all of you individually, believe that the current provisions in the bill are adequate, specifically around the involvement about medical professionals having with family members where a person is seeking an assisted death, and in particular in cases of possible coercion, if you think that there's adequate provision in the bill for your members to engage with family members or others that are relevant to the patients.
You start. I think involvement of family within decision making is important. However, I think as different steps along the way, if there are issues around coercion that, as we've said just before, could be identified as red flags, what I feel is that, you know, the complex decision making is hard. It has to be shared. It can't be just one person or two people making a decision around these things. And I think that's why, if then it has to be in a stepwise way, that's how we would do it in a clinical setting. So you have a conversation. If you feel that there's concerns, then you would either have them separately with the patient and or include family. But it is making sure, as we've rightly said before, around sort of training, red flags being raised appropriately, but then, you know, kind of the next step of what needs to be done thereafter. Currently, as it stands, these are the concerns our members and fellows have also raised, that they wouldn't know exactly where to stand if things were, and who to involve at what point as well. And I think that aspect is really important to clarify at this stage.
I think family is important, but even in the current system now, legally, family member can't consent for somebody else if they've got capacity. So I think there's some principles of autonomy that would need to stay the same, actually. So because that's as it is now. So I think the family are important. But in this particular case, the most important person probably is the person and their autonomy. So there's a really fine balance here that clinicians are going to have to strike between listening to the family and understanding concerns, also being very aware and vigilant to coercion. But actually, there is also the family, the primary person is the person seeking who this relates to. So I think there's got to be a very fine balance here, and I think the family is important, but the primary is the individual involved.
Thanks. And I think for GPs, there's no absolute answer to this, that we're very aware that I've done palliative care visits in the past week where I've been at a patient's bed with their relatives all around, all involved, and the patient very happy that family members make decisions for them or with them. I've been to other visits in the past where the one thing the patient doesn't want is their family to make the decision for them. So I think that's something that to legislate to specifically on what we should be doing at times might then be breaking the patient's choice. And I think it will depend where that goes, which side you're on. Are you wanting the patient to have the autonomy that's talked about, or whether we have an absolute that you must involve everybody?
Thank you very much. Bishop of Newcastle.
Thank you. Good morning, good afternoon rather, I think. No, nearly good afternoon. Thank you very much for your time today. I particularly want to acknowledge Professor Ranger and your comment about the importance of ensuring that the role and the voice of the nursing profession is not lost. And earlier we heard that we heard about the New Zealand context, and actually in their review, their 5-year review, they did say that the role of the nursing profession and the voice is something that had been left out in that context, and that this was not helpful. So I think you've given us some very helpful reflections today. Can I note and ask your opinion really on the Royal College of Nursing being worried that assisted dying and palliative care will become muddled? Because my understanding is that the policy intent of the bill's sponsors is that they should be integrated. Can you comment further on that, please?
I mean, I think there's a very fine practical balance here, actually, because there is I think there's no doubt that actually we know at this moment in time hospices in the UK are under real pressure. And I've been to many hospices at the moment where beds are closed due to funding. So I think we've got to ensure that palliative care is invested in and thriving, and actually every patient should have the opportunity to have a symptom-free, dignified, pain-free death. That should be what we're striving for. And I think it's shocking, actually, that in England, 42% of deaths are in hospital. That is not where any of us would probably like to die. So I think that's a really important piece of work that needs to continue to be invested in and still looked at. But that is separate from someone seeking assisted dying for themselves. And I think that's where our members are slightly worried that those two things may get conflated. And I think and the practicality of if someone does want to end their life, where that happens. Because whatever happens, our members feel people have got to have faith in the services. They've got to trust that if they go into a hospice for symptom control, and to have a dignified death without seeking assisted dying, that isn't something that's suddenly going to be offered them, and the same in hospital. So I think there's a practical element of how we are actually going to ensure autonomy and not create fear for anyone that is near the end of their life. And I think that's why there's a bit of a practical bit about how this is going to work in reality, because what you want, we feel as a college, is people to have faith in the system. They need to know that their autonomy is going to be respected and not be fearful. And that's why there's a practical element that both respects autonomy and respects a dignified, pain-free death, and they are two slightly different things.
Thank you. Can I invite the other two to comment, please?
No, I completely agree, because I think sometimes you conflate the issues together, because at the end of the day, you want patient choice, autonomy, very important. But then to say, if it's a broken system and the palliative care services as they currently stand, there's so much inequity of delivery. There's areas where it works really, really well, and then there's areas where it just simply doesn't. And then for patients to kind of be fearful that that they won't get any services and then opt for, whatever, for an assisted dying option, that's, again, if that's pure patient choice, that's not an issue. But what I really fear is that people are making sometimes these choices because of the lack of provision around good palliative care. And around going back to the inequity of services, I mean, it's so, feels really wrong. And a lot of our members and fellows talk about that just where the disadvantaged populations are, there's services under provision, and then that inequity and gap is just going to get wider and wider. So I think that's some of the fears that are coming through our members and fellows.
Thank you. I think as GPs, it's why we would feel a separate service is something that we'd be looking at and wanting to support. That patients coming to us shouldn't feel that they have one route or another. That as GPs, we would continue to provide holistic care to the patient right through to the moment of death, whatever way that happened. And we wouldn't want patients to feel that because of funding issues or anything else, they were being forced into a decision on that. We see palliative care as part of our core general practice contract. It is what we do. It's coming to a motion in our council in the next weeks to reaffirm that palliative care is core to general practice. And we want this, therefore, to be something in addition that might be offered, but not necessarily delivered as part of core general practice. We're particularly concerned about the under-provision in some areas. We know that some middle-class areas possibly have better access to services. We know that there's inequity across social demographics of all types, and some populations go to get hospice care or in community palliative care and others don't. And so we'd want to make sure that those marginalised groups don't feel that they're going to be moved one way or another because of that, rather than because of having an actual choice.
Thank you.
Lord Markham.
Thank you, and I have to say I welcome that for all of you. At the core of this is patient giving people the choice. I'd like to follow up particularly, though, the comments made about having a separate pathway, and really understand models that you've seen that you think might work in this context, because I think this is one of the key issues that we need to try and address.
Yeah, I don't think as RCGP we're designing a pathway. What we have is concerns about where GPs might find themselves, and we were pleased that our opinion previously that it should be a signposted service rather than a referral into a service is something that GPs would have a choice about. But what we don't want, as I talked about with palliative care, that blurring of lines. Where's the GP sitting in this? We have a number of concerns specifically. One of them, concerned about general practice, always about workforce and workload. If this is going to take 30 plus hours of GP time in a subject that you're not particularly skilled in because of the low numbers coming through per practice per year, that's something that will take a lot of time away from all our other patients. And it's not that we have a service that people can actually find 30 hours of time for their anything at the moment. We're completely full, whatever we do. We want to make sure there's a multidisciplinary approach, and that nursing care provides a lot of our palliative care. Would be anticipated to be nursing involvement and other medical specialties involved in palliative care, and those different opinions need to be there as well. So that is better done outside, where that can be coordinated not through general practice but for general practice.
Would you, if I may, and just probing that, would you see some sort of refer, because as said in terms of the nurses as well, you guys are the front door in a lot of these instances, so would you see some sort of referral, for want of a better word, to then another service?
We wouldn't want the word referral.
No, I know, but
that implies that we send someone somewhere,
sure.
And for those that don't want to be part of it, we want to make sure they have a way, but that patients can be signposted to somewhere that they can then get all the information that's needed, that they can then be part of this if that's what they wanted. So there will be a role for GPs. Patients talk to us about end of life. We will have been part of that diagnostic process that got them there, and so we don't want to lose that. We are part of patients' lives at that stage. We just don't know that there are many members who do not want to be the next bit.
So you're saying, and I believe this is nurses, and this is to all of you, that there's almost, as the front door, there's a certain level, and that will require a certain level of training, so that you can act in that front line role, but then beyond that, then it's signposting them to a separate service. Is that? Okay, thank you. And are there any international examples that you've seen that can help in this space?
I'm sorry, I'm not aware of any, but we can get back to you on that.
Okay. Thank you.
Anna Smith.
Thank you. My questions follow on very closely from Lord Markham's first question, which is really about time, because Dr. Mulholland, you've sort of pointed out that it might take 30 plus hours of a GP's time if they were responsible for being the coordinating doctor, seeing somebody through assisted dying on the basis of the proposals at the moment, the draft legislation. What is the average time of a GP appointment? And do you feel at the moment that you have the sort of knowledge of your patients that maybe I had when I was a child? The family doctor knew who we were. Does that still exist?
Average time, I think, is still somewhere just under 10 minutes. We're trying as much as we can in many practices to increase to 15 minutes because we know most patients come with more than one problem and complex worlds that they're now living much longer or with more disease. But do we have the same knowledge as when I started? I think we have a different knowledge. We have so much more detail, so much more information about the health conditions, about a course of a patient's life recorded now electronically, which when I was doing it was bits of paper that were illegible and unable to be read after a few years. So we have this vast amount of information that would help any doctor going through it and helps the patient navigate the health bits. We know, though, that GPs don't work out of hours, and they say we have a separate service of general practice out of hours, so it will not necessarily be the same doctor then. Practices, many of us work part-time doing other roles as well, so again you'll have differences there, but what we try to do in many practices is to maintain continuity for those patients that we recognise really need it. And patients in my practice, certainly it's those who have a cancer, a mental illness, those sort of things are what we want to make sure people have the same GP for that time. And as a college, we promote continuity of care because it improves the patient's life expectancy and more well-being, improves it for doctors, the way we deliver the service. So it's something as GPs we're very keen to promote. We just, as you suggest, are overwhelmed with the demand at the moment. So it doesn't always occur because we have so many patients coming in, often electronically, to get that first appointment.
Thank you. So following up on that and then turning to Professor Ranger and her comments earlier about nurses being very much at the front line. You pointed out that there was a toolkit that GPs can look at to check about sort of coercion and so on. But do you feel that as GPs you do have the time to understand patients' settled will, that you would know if somebody coming in was genuinely somebody who says, I want to exercise choice, or might actually have somebody at home exercising pressure and coercion? Or is this something we would need to add into this legislation to overcome that? And then the question to Professor Ranger would be, are nurses in a better position? Would they be able to add more?
There you go. Sorry.
I think, do we have adequate time to do that? As GPs, we know that our one consultation of 10 minutes is not our only consultation, and so I have a lifetime of consultations with some patients, which in my case have gone on 25 and 30 years. And so that is many, many hours of discussion and understanding some patients. I don't obviously understand them all. If a patient moves to my practice, I don't have that long-term relationship. I think we need to be sure that these things are checked on many levels. It's not on a single time and point where you tick something. Our nursing colleagues in practice, for many of my patients, they are now seen primarily by nurses for the chronic disease management, and so they may have a better understanding of what's going on, and teams will come and discuss it. So I think it's a multidisciplinary approach, and it needs to be checked a number of times through any process with as many people as possible.
Thank you. I mean, I was going to just follow something very similar. I think it's probably a little bit as described. It's almost a bit of a triage process. In the 10 minutes in the first conversation, you would get a sense of someone maybe highlighting their wishes, but of course you'd come back to it and you'd have to create separate time, actually. It's one of those conversations that cannot be in a fleeting moment. And, you know, experienced clinicians, you usually intrinsically You can't always measure it, you can't always write it down, but there's something that if you're good at what you do, you intrinsically feel this, I have to come back to this. This is a comment or a conversation that I can't just let it settle. I need to create the time to come back. That's very much how, you know, I think all doctors and nurses would see that. And that's why that, as was described, that sort of generic knowledge has got to be there, and then kind of either coming back to those conversations so that it's a progressive step, really, and really checking, you know, what's behind this. So that's why I think having the panel and having safeguards is key, but actually that continuity of conversation and relationship is also key, I think.
And I think from a physicianly perspective, I mean, from the front line, both in emergency medicine, acute medicine, and then into the hospital wards, one of the issues that we have is continuity of care, again, because it's so hit and miss of how that happens day to day. And the interactions, both in outpatients, is 10 minutes, but in hospitals is even shorter at times because of the number of patients that you see. And also the temporary care environment, sadly, that is such reality. I mean, we've published this week around, you know, any time of the year, corridor care is a huge issue. And I've had end-of-life discussions on a corridor. I mean, it's awful, and it's not the right place. So, and then that is desperation sometimes because people just want, you know, something out because that's how they feel. So the pressures on the system currently are such that, you know, that's one of our concerns as well, but both currently system pressures, but also workforce pressures in the same way, with many gaps, and then the training that goes with it as well. But that's day-to-day reality of what we face, sadly.
Thank you.
Can I move on? Yes, Lord Goodman.
Thank you. Baroness Berger earlier asked Dr. Mulholland about training in relation to GPs. I'd like to ask the same question to Professor Ranger. In relation to nurses, given the centrality of nurses as discussed in dealing with patients and delivering assisted dying. So, according to the impact assessment, nurses will receive Tier 1 training, 90-minute e-learning module, 60-minute online interactive session, not Tier 2 training and not Tier 3 training. Do you feel this is appropriate? And just as a follow-up, are you happy that even that level of training is actually not specified on the face of the bill?
I think it does need strengthening, if I'm honest. I think that 90 minutes to me is that basic triage, it's that basic signposting. If people are really going to be involved in listening to people's autonomy, you know, being able to help advocate or in any way be part of, as in Scotland, where nurses are actively potentially involved in the assisted dying in Scotland, then the training would absolutely have to change and go up and increase. I think that would be absolutely key.
And you would like to see, if it has to be Tier 1, it set on the face of the bill, presumably, so it can't be watered down later.
I think so, absolutely. Because I think it's key. It's got to be, public have got to have faith, both in the people potentially involved in assisted dying, but also in the expertise. I think that's key.
Thank you. And to Dr. Mulholland, in your evidence you say, quote, any assisted dying service should be seen as a standalone specialised service healthcare professionals may opt to provide and should not be deemed core GP work. So I'm on the Delegated Powers Committee, which has made a great deal of the matters that are not on the face of the bill, but are simply left to ministers to put forward by regulation. So this is all covered by clauses 41 and 42 of the bill, which will enable them to deal with the whole matter by regulation. In other words, by regulation, this could become core GP work. Are you satisfied with the legislation being dealt with in this way?
No, as a college, we'd hope that this goes on to the face of the bill, that we would have a separate service, and we will be seeking peer support for an amendment to that effect. We think if it's there for regulation and later amendment or change, there's no protection long term, and that's what we'd like to be there from the beginning.
Thank you.
Lord Goddard.
Thank you. And welcome. And it's good to speak to people who actually, if we are on the coal face and interacting with the patients, which is the heart of this bill. And I welcome the comments that choice is to be welcomed and the need to respect autonomy and faith in the system. And so my question to you about the system is, what would you give what would give you the confidence to embrace the system and embrace the process? And would it be putting it on the face of the bill? Would it be on more recognition of nurses and doctors' responsibilities and training and the cost that goes with that? Or is it a bridge too far? Is it something that you think your members on principle wouldn't embrace? Because what we're trying to do here is to cross the hurdles, and I think one of them is, and you've explained extremely well this morning, are the concerns of doctors and nurses and the system. So is it possible there's a way we can, and it might be with those amendments, actually cross those bridges? I'm just reaching out to ask if that's possible.
I think as a college we've wrestled with this and came very clear to us when we talked to members about what they felt about it, that no one opinion was going to respect every member's view. And what I could say, we are for assisted dying. I had very strong, and get some support, I had 40% of our membership were on the other side. And so what we needed to do was say we are not about the bill itself, we're about what's right for patients and what's right for general practice and for our general practitioner members. So I don't think there's one thing that would fix it for everybody. I think there will always remain GPs that are firmly against assisted dying for whatever reason, and that's why we would like the opt-in clause, so that they don't feel that they have to be part of it, or they don't have to be part of it. And what we need to do is make sure then on the other side that our patients have the protections they need for the vulnerable. They also have the ability to exert their autonomy and their choice when that is something they want, if this is to become law. So we're looking at the protections for both the GPs and the patients, rather than trying to make everything work with a form of words, because we're aware there will be different opinions, whatever happens.
I mean, I think that's exactly the same for us. Very simple. We would, our membership, we have strong people in favour and that would really support assisted dying, and an equal number that are opposed. We would want protection for any clinician, particularly nurses, that respect for their decision. And as a college, we would support our members making either decision, and we've been really, really clear on that. I think there could be a potential that the bill will never cover everything, but I think there's something really important as a principle with the bill is about respect for autonomy. When we get it wrong in healthcare, it's usually because we're being paternalistic. And it's really important, whatever safeguards are there, whatever process, whatever system is there, the underlying basis, we believe as a college, has got to be autonomy of individuals and patients as a bedrock. Legally now, patients and people are allowed to make an unwise decision. That's already in the law. So we've just got to be really careful that we don't have such a high threshold that actually the principle of autonomy gets lost. And I think we will never be able to have a bill that covers every risk, every potential. So I think we've got to have strong safeguards, something that is, people have faith in, whatever side they are. That's what I think the bill has got to be able to do. If you're against it, you feel comfortable. If you're for it, you feel safe. And that's the bit that I think the bill needs to try to be able to create. But at the principle, have autonomy and respect for individuals.
And agree from a physicianly perspective as well, with the same principle aspect side of things as well. And we have a breadth of views within our membership as well, and it's really hard when you're having the conversation of how do you make it practically implementable, because if you have one position, then people will want to make it work and others may come up with more things. But I think practically workable, ethically robust, and making sure that that compassion and empathy and care for the patient isn't lost along the way, because we feel differently about it. And what we want is that if it goes through, we just want to make sure that all those safeguards and protection aspects are there, both for patients, but also for our staff, because what we can't have is then, you know, people feeling as though they're excluded or not supported along that journey as well.
Thank you. Thank you. Before I call on Baroness Finlay, Lord Patel, at the end I'll give you another opportunity, and also Baroness Berridge. So, Baroness Finlay.
Yes, thank you. And thank you for coming. And Dr. Mulholland, you raised the issue of a separate service. And that's really interesting, because there have been papers written about having a separate service. University of Lancaster, I think, have produced quite a lot of thought on that. And I just wonder, for both, particularly from the hospital end and the nursing end, how you feel that a completely separate service might help, given that currently our hospitals are running at about 90% capacity plus. Most of the time we have patients in corridors, as you've said. We have high staff sickness rates because the staff are already pushed beyond the limit, not just to the limit. And I just wonder how you feel that in our current system you could manage patients having lethal drugs in, for example, a 4-bedded ward with curtains drawn round, or with a side room. And if there's such pressure on side rooms at the moment, how would you decide the patient who's perhaps septic or a infection risk to others, or a risk because they're so confused, to move them out in order to move such a patient in? And I'm intrigued at your suggestion of something which is quite separate, because it may also solve the problem. Some people expect this to be done in hospices and have even suggested hospices would take this over, and yet, as you have said, there is a great deal of fear already around hospices, and they often get labelled as death houses. They did in the past, and I should, forgive me, I should have declared at the beginning of the session that I am a consultant in palliative medicine with a session at Velindre Cancer Centre and an honorary professor of palliative medicine at Cardiff University. Sorry, I apologise for that coming late.
Me?
Yeah, I can follow. No.
Yeah, I think there is a risk of blurring of whatever it is, whether it's a hospital service, a GP service, or hospice. And I think we want to make sure that patients know where they are, that they don't fear that coercion, even within the system, by being in a place that maybe has got a mixed role. If a patient makes a choice, this is going to be an enormous decision for any member of the public to go ahead with. They will have weighed it up. They want to know that their pathway is clear, I think, as well. So I think there's lots of reasons that I talked about earlier, but I think something that is a separate pathway within medicine has got to be probably the best and safest way for patients and clinicians.
So I think I agree in principle of having separation of pathways. However, I think the practical delivery aspect is huge, isn't it? It's so difficult at the moment to, what you don't want is diverting of resources to make one happen at the compromise of another service. And that comes back to, again, the equity of access, support, and we're already under-resourced both from a system perspective but also from our staffing perspective. So, you know, as you said, vacancy rates, you know, not just staff recruitment, retention, but also morale within our workforce is huge, and the moral injury aspect side of things. So, you know, separate pathways, yes, in principle, but then adequate resources to back that up so that one isn't compromising the other. And the last thing I'd want to see is that the palliative care services, which are already under-resourced, the current situation or direction of travel makes that even worse. And we've produced some reports, as you probably know, around the palliative care services this summer, just highlighting that in detail.
I mean, I think whatever pathway, and I agree with my colleagues, it would need to be very carefully thought. It's got to be good quality. You get to die once, and it's got to be done well. And actually, it's heartbreaking if we think that if you were seeking assisted dying, it would be in the middle of a 4-bedded bay in a hospital. That's a failure. So the whole point of this is to do this well, respecting autonomy. So it's got to be both practical, but also brilliant. It's got to be if someone's seeking to die earlier than maybe nature would had intended, it's got to be a comfortable and dignified death. So I think there's just got to be a practical application. But I think if someone's seeking assisted dying, there has to be something in whatever setting that is really done well for the individual and their family. Just being stuck in the middle of a medical ward with alarms going is not what I think this bill intended, or the individual seeking assisted dying would intend. So I think there's got to be practical application, but striving to do this well.
I think we wanted to come back in, Dr.
Sorry if I just make one more comment that Mumtaz prompted there, that the moral injury, the psychological distress to people that are, it's tough at with palliative care anyway for every person, and within the system there is provision to support those colleagues. Colleagues that are involved in assisted dying will need that and that training as well. But it's not just our clinical colleagues, it's our whole staff. And if it happens in general practice, it's my receptionists, it's the management, it's the administrators. And the conversation, we as a Medical Royal College obviously focus on GPs, but we as the GPs, we're part of a team. Hospitals are part of a team. And if it happened in that side ward, who are the administrators that are having to do it, the pharmacists, everybody else that's coming in and out, the clinical and non-clinical teams?
Could I ask you one more question? With the bill as it's written and from the impact assessment, the panel must hear from and may question the coordinating doctor or the independent doctor, and similarly they must hear from and may question, they don't have to, the person to whom the referral relates to the panel. But from the impact assessment, this could be a very junior doctor that's involved. And I wondered whether you're comfortable with that level of inexperience, or whether you feel that it must be a very experienced doctor, and also whether you feel that actually the nursing staff involved must have the ability to have some input into whatever report goes to the panel, because they're often the person who's been most with the patient. I'm
afraid we'll have to break for 10 minutes and then come back, please. We're now resuming the session which we were interrupted by for the division, and I'm going to return to Baroness Finlay to put her question, which was partly put, but perhaps could be put more fully.
Thank you very much, Lord Chairman, and I apologise. I'm going to repeat it in case we've all forgotten some of it, but it related to the panel. Because the panel must hear from and question the coordinating doctor or the independent doctor, and similarly must hear from or may question the person to whom the referral relates. But they don't have to hear from anybody else at all. They don't have to hear from both doctors. They don't have to hear from nurses who've been involved. They don't have to hear from the GP or anyone else. And I wonder whether you feel comfortable with the role of this doctor actually being potentially a very newly qualified doctor, as outlined in the impact assessment, or whether you feel that there must be much more information gleaned in order for the panel to take a decision. But I'd be interested to know what you feel.
On this one, it's difficult. The whole question of making decisions for assisted dying is against everything that I've been trained in and I've practiced for 30 plus years, because the outcome at the end of life has been we will support and care for you and provide palliative care as best we can in the circumstances. So in my mind, it's a difficult decision. It's something that you would need a lot of evidence and support for, particularly as it comes in as a new service. Who the doctor is, there's often a process of senior decision making in healthcare, whether it's in hospital or general practice, and more difficult decisions are often referred to someone with more qualification or more experience to help this. With a patient in general practice who has got difficult decisions, we often refer back to the colleague that's got the best relationship or knows the patient best to help with those decisions. And so I think whatever way a decision is made, it's going to rely on people that have got the experience to make difficult decisions, the knowledge and the understanding of the patient, and if that requires you to get information from nursing colleagues, from patients' families, from whoever, that's going to be important in that. But then it's also going to be a difficult decision for those that are actually making the final bit, which probably requires some more senior decision making than new people, but that will depend on their training.
And similar to that, I mean, in clinical practice, complex decision-making is shared. I mean, we take away the onus from an individual because things can go wrong, and particularly in these kind of critical decision-making, what we would see in normal clinical practice is that there's an assessment, follow-through, and then a wider MDT discussion around a patient and then what's best for the patient, but involving the patient within that care. So in the way that the bill is currently placed, you know, clinicians being experienced is really important, face-to-face assessments is really important, and then the wider decision-making has to be done, you know, kind of as a team and shared decision-making. And somebody who knows the patient well, and I think that goes back to the continuity, etc., but I think the experience is important together with the shared decision-making, and any assessment has to be done face-to-face. I think, you know, panels, remote, not knowing anything, and just faced with paperwork. We were discussing that as an issue previously as well. I think that's so important to have that connection with the individual patients as well.
Yes, I think there is going to be a balance between experience but also skill and ability. So I don't think experience should trump everything, because actually you can have someone very inexperienced that's not a brilliant decision maker. So I think it's the combination of both experience and good decision making. I do think there is a potential, when I looked at this, about the panel, because there's a real potential that the person's voice could be a bit lost in the panel to whom the decision relates. And I think just to rely on paperwork or not having the ability to advocate for yourself, or because I think we all know, you know, you can read something on paper and meet the person, or guess it's completely different. And I think there's because the worry potentially is if it's just seen as paper, little bit bureaucratic, people may not feel that the process was fair or totally represented. So I think there's a balance both with safeguards, getting the right people with the right experience, but also the person or the public who's seeking a decision needs to have confidence that they were fully understood and their issues were understood.
Thank you. Baroness Berridge, and then I'll come to Lord Patel.
Thank you. You've referred mainly to having had training to do with coercion and safeguarding. Now, in the bill, it does refer to the fact that at least the independent doctor will need training in coercion or pressure. Have any of you had training relating to pressure? Not coercion, pressure.
I want to completely understand what you mean. Pressure from ourselves or pressure from other people?
It's not defined in the bill, so I'm afraid I can't help you. We've got no definition in the bill. Yes. You are going to need training, though, in pressure. Have any of you received any training like that? No. Thank you. And particularly to the Royal College of Nursing, you picked up the inconsistency in the bill regarding the conflict between, I think it's now clause 31 and clause 5 in relation to the ability to opt out. Can I just clarify, forgive me if I didn't understand you, are you supporting the opt-in model for your membership? Because you've got quite a global membership, haven't you, from places in the world that are much more religious than the UK?
If we would feel if you wanted to be involved in assisted dying, you'd have to choose to be involved, but then you also have the potential, if you didn't want to get involved and it was happening or around it, which I couldn't imagine happening, you can opt out. So we want to be absolutely clear that nurses can say, I want nothing to do with it.
Right. And
as they do with abortion, actually.
Thank you. And just finally, having read the bill, it's not clear to me, but maybe I've misunderstood the bill. If you come upon information that leads you to believe that you've not been involved, but you happen upon information that the person has been coerced or pressure put on them or circumstance pressure, is it clear to you the avenue, or maybe it's through your professional body, where you would intervene in this process to raise the alarm and say, stop the panel, there's additional information that is needed?
I mean, I would have, as it currently stands, I think that goes back to a safeguarding process. That there's and personally, I think setting up something completely different. I think a process that's understood since Victoria Colombier. I think keep going with the same process. It's something that does people know or should know to phone a number, make a referral, and say they've got concerns.
Right. Thank you.
Lord Patel.
Thank you, Lord Chairman. First of all, can I say you GP and nursing referred to community palliative care, and I support that from my own experience. It was a brilliant palliative care provided to a member of my family, both from GPs and nurses. So I commend that we need more community palliative care. Can I come back to the question that was just raised about the panel? You made a point that face-to-face decision-making is the best, and I have to agree with that. So how do you think it would work in the current context of the bill if a panel has to make a face-to-face decision? How do you think that will work?
And we haven't... do you want to give us?
Yeah, I guess we don't... what I would presume is that the panel will be informed by the face-to-face assessments of individual experienced clinicians who have been involved with the patient care, and they're part of the panel then. I mean, I appreciate that not every single member of the panel may know the patient.
We're talking about the panel speaking to the clinicians who were involved.
Yes, or the teams involved.
Or the teams involved.
And with a representative who've informed them following assessments in that way. I think that was my how I envisaged it to work.
You're nodding too, yes. So you agree.
I agree. I think, as we talked about, the workload pressures mean that, and the infrequency of this occurring, as the panel is unlikely to be on site beside where this decision needs to be made. So it'll be, they need to talk in some way as close to face as possible with those involved in the care.
If I were to use the word pressure, and if I use word coercion, how would you interpret the two?
I think it's grey. That's what we were sort of saying. And again, with regards training and things, I mean, certainly...
Apart from training, how would you regard the two words? Are they the same? Are they different? If they're different, how are they different?
I think well, for me, pressure, how I would say, coercion feels like it's something over time. Mm-hmm. Coercion feels like you get the person to think it's their idea. That's how a simple way I would see coercion is that you lead someone to feel it's them, whereas pressure feels it's a bit more obvious. And I think you've got to probably know a bit about both.
Very simple question next for each of you. In your everyday work, are you able to decide whether the person, the patient that you're talking to, have a capacity to make a decision or not, even those that are near point of death?
Go on, use that.
I think yes, in the decisions that we're asking people to do. Do you want to have antibiotics near the point of death for your chest infection? Some of my patients will say no, some will say no, I've had enough. I don't need more treatment on that, but that's a straightforward decision. We've talked it through. It's a very different decision.
You make a judgment that they have a capacity to make that decision.
On a straightforward thing that I can explain the risks, the benefits, the outcomes and not. We have a shared decision then. It is not my decision, it is a shared process. I think as the decision gets more complex, the safeguards you need to put in around that increase. And if it's a surgical procedure, we see the long lists of things that patients must have gone through and discussed before they do that. Going through it with assisted dying, you would anticipate the list would be longer and would require a much longer process. But effectively, every person that comes into me wanting a chest, me to listen to their chest and give some antibiotics, I'm judging their capacity to ask or take them or not take them as we go along with that.
Either of you make any comments?
Yes. Similarly, in hospitals, we do the same. So patients that come in and the judgment, the clinical judgment would be what's in the best interest of the patients. They are presented with this is a treatment. Now, when there's more complex decision making, which are leading to, so even the Capacity Act as it stands, it assumes capacity and decision making around that for giving treatment, not giving treatment is one aspect. But then if you're using the same principle to assess a patient to say are they capable and do they have the capacity to make those decisions about ending their life, that's a separate matter, and that's what we're saying, that we would then want a wider assessment on that. So my clinical judgment...
What wider assessment would you require?
So that's where, I guess our position statement with the Royal College of Psychiatrists was quite clear that the Mental Capacity Act in itself doesn't give the framework for assessing capacity for this particular aspect. And the wider capacity assessment would be more multidisciplinary, people specifically trained to assess capacity. So I do some capacity assessments for some of my patients, but that would not be
So you're saying that ordinarily your members will not be capable in that situation. Okay, nursing, sir?
Yes, I mean, I think I agree with what's been said. There is an assumed capacity unless shown otherwise, and I think that's the principle of which you would enter this. There is a danger, though, with the capacity, and that's why it does need certain assessments. I used to be a nurse consultant in critical care, and people used to say, well, actually, I've had enough, and then you would get, and they're depressed. So there is a fine line between respecting autonomy and actually that assessment, and I think that's why you would have to seek that panel, that second level capacity if required.
Before this session finishes, just 2 points on declarations of interest. Lord Goddard, I think you want to correct what you said earlier.
I need to correct my declaration of interest. I'm in fact the Vice Chair of the All-Parliamentary Group for Choice of End of Life. And I said Dignity and Dying, they're the Secretariat. That's where the study group.
And Bishop of Newcastle, I think you...
Thank you. Yes, I should have said that I have no relevant interest to declare. Thank you.
Yes. Now, there is a little time. I think 2 people want to come in, Baroness Berger and then Lord Winton?
Sorry, Lord Chairman, do I need to say that I have no relevant interest to declare then? I didn't declare them because I didn't have any.
Same here.
Did you? I can't remember.
I didn't declare, but I don't have any.
Yes. Right. Well, Baroness Bircher, and then I'll come finally, if I might, to Lord Winston.
Thank you so much. Just also to clarify, I have nothing irrelevant to declare. I have a very short question just for clarification, and then also a very short question. Professor Ranger, just for complete clarity, you mentioned again just a moment ago about the safeguarding system, and if you can share with us where you think this is already adequately covered in the bill, but if it's not, where you think or how it should be added.
I think there's got to be simple with regard to the referral. So what, in my view, if you've got concerns, that would need to be a referral into. But
Forgive me, but can I just specifically my question, do you believe it's adequately covered in the bill, or do you believe it's not, and therefore if not, where it, so you're saying it's not and therefore it should be added in the referral, is that?
So I think the basis around you can refer to the safeguarding hub is okay. With regard to extra scrutiny, it comes back to what you said earlier, the what if, once that referral's made,
yes, and
the due diligence in the investigation, that will probably need to be potentially strengthened, or there's the practicality of if a safeguard, if you think someone's being coerced or, being for financial gain or whatever it is, the referral needs to be simple, and I think that should probably stay. It's potentially, once you've made that referral, the investigation into what's actually happened or happening. That happens now in child exploitation or trafficking or whatever, but it will need to be another area that may need extra training. Does that make sense?
Indeed.
Yeah,
thank you so much. Also, in two of your earlier contributions, it was both the Royal College of GPs and Royal College of Physicians, you mentioned the potential serious issue of moral and psychiatric injury of your members, and also applying to the wider staff body. How do you believe that we should support GPs, physicians, nurses and that wider health staff body if it turns out afterwards somebody has been subject to coercion or pressure? And I'm thinking about some cases that have emerged in other jurisdictions where this has been the case.
I think at the moment, we need to be really honest about the current environment that many clinicians work in now. I think we are becoming incredibly intolerant of mistakes, intolerant of the fact that clinicians are human, and any kind of healthcare is not an exact science. You see people's lives ruined on social media. You see that their career comes to an end. I think this has to stop generally, because I think it's poor for healthcare, and I think it's absolutely vital it's exactly the same in this circumstance, because I think, sadly, whether we like it or not, we don't keep doctors and nurses safe now, and that's the honest truth. So I think anyone who knows that they're involved in any kind of decision at the moment, if it turns out that there are mistakes happen or there's scrutiny, I think it's very difficult for them now, and I think we've got to put, with or without assisted dying, I think we've got to do better than we're doing.
But forgive me, obviously, on the issue of assisted dying where someone's life has ended, if I can ask specifically in that context, what you think should happen?
I think there will need to be that support. That peer support, that structured,
longitudinal support.
Psychological support, peer review, sessions where they get to reflect, and support. And I think it's important that we recognise that right from the beginning. People are making difficult decisions, and it's not an exact science. It never will be.
Is the degree of
Sorry, can I interrupt? Various people want to ask questions. I think you've had your shot. Lord Winston.
Thank you, Lord Chairman. A very brief question, a very brief answer. I may have misheard because of the top end of the table, and actually it's not very good acoustics in this room. I heard the suggestion that a dying patient would have to be removed from a hospice and put into a separate place for treatment. Do you think that is feasible or humane?
Personally, I don't think you'd have to be removed. I don't think. I think it's got to be, but it's got to be whatever process there is. It's just got to keep faith. People have got to recognise that this is about autonomy, and if it is in a palliative care or hospice setting, really clear that that decision for assisted dying comes from the person. It's not a treatment option that will be suggested to you. So if it is in a hospice or someone's home or in a hospital, I think that's important. But the most important thing is that that patients and the public feel safe that this comes from them, not a treatment option that's put to them. So if it means it is in a hospice, I know that would be difficult, but that feels more humane to keep someone where they are. It's about person-centred care.
Thank you.
Can I just pursue that slightly, because the suggestion has been that patients could be moved to a hospice from a busy hospital ward, which cuts slightly across that. But I'm also hearing you say that you don't see this as a treatment option. But if the doctor is raising this with any patient to whom this might be an option, where does that sit in relation to the Montgomery ruling and the requirement that you raise issues that may be options for that patient's management if this is viewed as a treatment option?
I think I'm struggling a little bit with why the patient would be in a hospice if they were going to make another decision, because it would be quite a... At hospice care is end of life generally, and this is not a process, as I understand the bill at the moment, that can be rushed through. It's not a 2-week process, it's not a 1-week process or an overnight change of mind. It's something that will require time, panels, consideration, a lot of evidence. So I think our argument about a separate service would helpfully separate that. But I wouldn't think that doesn't mean a patient wouldn't die at home if that was their choice. Patients, we know that the majority of patients would like, or people would like to die at home, and that could still be possible under assisted dying or palliative care. The community services are there if the services are there for both. I think the Montgomery ruling is an interesting bit. That's probably going to come much earlier in down the line, where as GPs, or nurses in the clinic, we'll be signposting people one way or another. We'll say, these are all your options. You can make choices at any stage, but understand the process that goes with this. So I think it is something that we will have to address, whether through signposting or other ways, but it's not something I would see very close to the end of life at hospice time.
And it needs to be a continuous, compassionate process, isn't it? I think rather than... Sorry, apologies.
I beg your pardon. You wanted to add something?
Yes, sorry, I was just going to add to that, as in, kind of moving, end-of-life care is meant to be supportive, compassionate, and what the patient wants. Moving patients from A to B just because a change decision from one aspect is just not, I feel that it's not the right compassionate thing to do for patients. So what you want is that continuity of care to be preserved, and the care to be preserved in whichever setting the patient chooses it to be. I mean, that's the ideal that we're wishing for, rather than swapping and changing. And again, it's not meant to be a bad thing for the patient. It's meant to be what they want to happen.
Professor Ranger, I think you wanted to add something?
No, I agree with what's said. I think there's something about, I think there will be some grey areas. I think you're right, it will tend to be a plan that there'll be a lead up to someone's death. But I think the key, I think with the issue with regard to treatment option, I still think, the whole principle of this is it's got to come from the person. So it's not something that you would suggest, do you want chemotherapy or do you want assisted dying? That is just not. Treatment option is exactly that treatment. This is about the principle that comes back to autonomy. This is one thing that needs to be driven by the person and then facilitated. It's not something you suggest to somebody else. Have you thought of assisted dying? Absolutely not. And I think that's, but if having a good death that's symptoms-free, good palliative care should always be a treatment option for everybody. There is a slight difference.
Baroness Berridge.
Just following up from your helpful comments, Professor Ranger, about the culture that we are in. And it may be that you need to come back on this because it was from evidence in the previous session. And we had the clarification from Lord Faulkner that without any mental intention, if a nurse or doctor inadvertently puts pressure, it might just be through circumstances not providing a hospice bed because it's not defined, and there's no time period, this can be way before terminal diagnosis, inadvertently puts pressure that then induces a person to either make a declaration or self-administer the substance, there can be a prosecution without any mental intention whatsoever with the consent of the DPP, with a sentence of either 14 years or life imprisonment. So it may be that you can't, I hope I've summarised accurately, looking at everybody on the committee, what the evidence was of Lord Faulkner.
I don't think he was saying that with regards to doctors.
It applies, it's a person in clause 34. So you may want to come back to me after asking your members, but because you're talking about the culture, we now have relatives able to say, blank amount of time before this, they were even diagnosed, there was pressure put on my mother, and they can go to the DPP and ask for a prosecution here.
That's the evidence.
So I don't...
That was his...
I think we've got to be a bit aware of the fact that we've gone well beyond our time now, and there are limits to how far we can engage in that discussion. But Bishop of Newcastle, just very shortly, please, finally.
Yes, just very shortly, just picking up on the earlier discussion about inequity and access to palliative care services. I just wondered if our medical professionals think it's unwise to proceed with the bill until we have equity of palliative care access.
That's a difficult question, but actually, if this is driven by autonomy, which I believe the principle of this, when you read what many people asking for this are striving to seek, then whether there's a good palliative care service or not, if the primary driver is autonomy, then actually it probably shouldn't make that much difference, because the primary driver is not pain and symptom control for many people, it's the autonomy. And that whether you've got a good palliative care service or not, if that's the primary driver, then it feels that the two things potentially shouldn't be conflated. That's a difficult question to answer, but...
Yeah, and our college, in our position statement, sort of reference in a similar way that patient autonomy choice is really important, and it's the equity of access to all the choices that they would wish to have towards the services for end-of-life care, and that includes very good palliative care, but also other options. So it's equity of the access. We have also, kind of supported and published reports around how the palliative care services in general could be better, but I think that needs to be done in tandem.
It does.
Rather than one following the next.
I agree with that.
Very shortly, please.
Very quickly, we would support that palliative care services aren't deprioritised in any way. We always want to have more for palliative care, but we don't want this to mean that people don't look at palliative care funding and deprioritise it in any way. But we would hand it back to parliamentarians like yourselves to make the decision.
Well, we'll have to leave it there, I'm afraid. You've been extremely patient with us, and I think you also will grasp from the questioning and the amount of questioning you've got right across the committee how valuable we found your presence today, and we're extremely grateful to you. And we end really with those words of thanks, and my final word is do look at the transcript, because it's important to us to know whether it's an accurate reflection of what you're trying to tell us. So thank you all very much indeed. We finished the session at that, and we'll be tomorrow for the next public session at 10:15.